Today we're going to discuss the confidentiality of a patient's medical records from both the perspective of the criminal view as well as how the Texas rules of evidence affect the confidentiality of patient records in the civil arena. Initially, there is no doctor-patient privilege under 509 of the Texas Rules of Criminal Evidence that protects the confidentiality of communications between the patient and his or her physician, with one exception. If a patient is being treated for substance abuse or alcohol abuse, or in fact is receiving information from a doctor or anyone affiliated with the doctor for the purposes of treatment or rehab for alcohol and or substance abuse, that information is the sole exception and cannot be used in a criminal prosecution. We also have the so-called HIPAA Act, which parallels to a degree the civil doctor-patient privilege that does exist, with a few exceptions. Under the Health Insurance Portability and Accountability Act of 1976, otherwise known as HIPAA, it specifies that there are a coverage of confidentiality between information related by the patient to the doctor and his or her treatment of that individual. Generally speaking, that also goes to the records that the doctor may in fact generate on behalf of the patient in consultation. The HIPAA Act covers what is known as covered entities, and those covered entities are a health care plan, the health care provider, and a health care clearinghouse. The health care plan is in and of itself able to be explained just by sheer definition. Health care provider includes doctors, psychologists, dentists, anyone engaged in the medical profession that treats patients. The healthcare clearinghouse basically is an administrative, insurance-related situation. Those entities can, in fact, be compelled by court subpoena or a court order to turn over specific information to the court for either an administrative proceeding or a criminal proceeding. The entity is not in and of itself protected. That information can also be provided to the judicial proceeding by way of consent of the patient, and the patient may limit the amount of information as far as the consent is concerned that is provided by way of that individual's consent. It's important to note that in the civil arena, there are exceptions where HIPAA does not apply, and that would be, for instance, when a doctor would be sued by a patient for malpractice, when there might be a grievance filed on behalf of the patient against the doctor, and those are two of multiple exceptions that permit the disclosure of patient privilege communication. Now let's look at a situation that develops as a result of a court subpoena. Or a court order. once a subpoena is issued pursuant to a court order for an individual's medical records, to include mental health records, and those records are complied with, or being the entity is complying with the court order and providing those medical records, does that make those medical records public information? And my response would be, no, it does not. It does not, because the public in and of itself is not a covered entity. And as a result, the confidentiality still relates to the judge or the court that happens to issue the subpoena, and those records cannot be made public. The purpose of the HIPAA Act and the doctor-patient privilege under 509 in the civil arena, and again the exception in the criminal case, because there is no doctor-patient privilege in the criminal arena. The purpose is to encourage the patient to be forthright with his or her physician, so that better medicine may be attained in the treatment of the patient. If the patient happens to believe that whatever I tell the doctor is going to end up being made public in some way, shape, or form, obviously that patient is not going to be compelled to be as forthright and open with the particular physician. Lastly, there's a common belief that if a third party sits in on a doctor-patient consultation or treatment, that breaks, and again civilly, breaks the confidentiality of the doctor-patient privilege. Not always, and the exceptions, of course, would be, for instance, if an interpreter is necessary to sit in to communicate, the doctor-patient privilege still exists. If in fact a member of an individual's family, a mother or a father, can sit in to help encourage the son or daughter to be forthright with the patient, with the doctor, then that third-party relationship is not violated as a result of the third party sitting in. And finally, it is the patient's privilege. It is not the doctor's. But the doctor can invoke on behalf of the patient the confidentiality of the doctor-patient privilege, but it has to be on behalf of the patient. Thank you.